Welcome back, everybody. If everyone wants to take a seat, we'll get started again. I hope everybody had a good lunch, a good opportunity to socialize. So we are going to get started with our next segment, and it has to do with an employer's responsibility to accommodate their employees. And so with me is Lori Alexander from Littler Mendelson. And so we'll just get started. So welcome.
Good afternoon, everybody. It's a pleasure to be with you this afternoon. I've got to say I was thrilled and excited when I was asked in June to talk about the very most positive and optimistic topic in this whole conference, and that is our post-pandemic duty to accommodate in November, right? So the prediction in June was that we would be post-pandemic. But in all honesty, my presentation is going to be more like last part of the pandemic and post-pandemic duty to accommodate, because I don't think we're quite there yet, although we're doing really well in Connecticut. Today is a very exciting day, as all of you with more than 100 employees know. This is the day that Federal OSHA was going to, and did first thing this morning as I was driving here, drop the emergency temporary standards that talks about mandatory vaccines being required for employers of 100 or more employees. I haven't read the 490 pages, but I can hardly wait to get back to the office to do that. But as I understand it, it will have a testing alternative. Will go into effect January 4th. The testing alternative is weekly. There was some discussion about whether that would be more frequently, but you'll want to check various websites later to get the summaries. I know on littler.com we probably already have a summary up on that. But that does play into some of the comments I'm going to make today about reasonable accommodations, because how many people here have 100 or more employees in the United States? So more than half. So you're going to want to look at that carefully, and you're going to want to prepare yourselves for lots of requests for accommodations for religious beliefs and medical accommodations. And we'll talk about that kind of at the end of the presentation, but very timely. So my practice was half litigation and half advice until March of 2020, when litigation stopped and everybody didn't know what to do about being sent home. What do I do? We're closing the office. How do I keep my employees safe? And I actually want to congratulate everybody in this room, and you ought to look across the table and congratulate your colleagues for getting through a heck of a year and a half. I mean, most of you are either CEOs or HR representatives, leads who have been making decisions on the fly about things that have been very uncertain for a very long time, and it continues. And so that's why I give advice most of the time now, and my litigation has really taken a back seat. But think about what we've been through. We had to close our offices unless we were essential workers, and then we had to decide what are essential workers. We figured out remote work. We figured out masking, social distancing. We imposed rules about cleanliness, and we had to do training, right? We had to assign a COVID person in charge of cleaning for our offices, and now we're grappling with mandatory vaccines. It's quite a lot for a little short period of time. So in thinking about my topic today, last part of the pandemic and post-pandemic duty of reasonable accommodation, I thought it would be good to talk first about the ADA framework. Let's start with the law. And this is going to be a review for everybody here, but I figured it was worth spending 5 minutes on what are the duties of reasonable accommodations. But just to get a sense of the audience, how many people have already had requests for reasonable accommodations in the form of working from home? You know, employees saying, I've been doing it for a year and a half, why can't I continue to work from home? That kind of thing. Quite a few people. How about accommodation requests from long haulers who say they still have symptoms? They need to have workplace accommodations, just a few of those. How many people have had religious accommodation requests if you're imposing vaccines? There will be more of those. And my personal favorite, how many people have had people say that they can't get the vaccine for a medical reason and they can't be tested because the swab is an invasion of having foreign matter be inserted into their body? Okay, that's fairly new. Yeah, you have. See, there's 4 or 5 people already. I'm not the only one. All right. What does the ADA require? Americans with Disabilities Act, as you know, it's a federal law. We have the state equivalent under the Connecticut Fair Employment Practices Act that also has a duty of reasonable accommodation for employees who are disabled. And we'll talk about what that means. So what are the duties? 1, you cannot discriminate against people who are disabled. We all know that. The second, which is what we're going to talk about today, is the affirmative obligation to accommodate individuals with disabilities if they require accommodation in order to perform the essential functions of their job. It's kind of a mouthful. But if they require an accommodation that's not an undue burden in order to do their job, you're required to talk to them about the accommodation and work out something that is reasonable. And then the other duties under the ADA and state law are confidentiality. You have to keep medical records confidential. And certainly there are limitations on the medical inquiries that you can make for employees. So the classic ADA principles are these. The definition of disability is very broad. You don't often fight about whether someone who has a medical condition meets the definition of disability. It's a pretty broad term. Under federal law, it's someone who has a medical impairment that affects an essential function of their work, an essential function of their job, or impacts a major life activity, which can be a lot of different things. Under state law, the definition of disability is even broader. It's anyone with a chronic impairment, whether or not it affects a major life activity. So anything short of a temporary medical condition like a broken arm or a broken nose or something that will, or the flu, which you'll get over, usually disabilities are covered if there are any sort of medical impairment. And in terms of basic accommodation principles, remember it's a very low threshold about what communication is required of the employee. They don't have to use any particular magic words like say, I have a disability, I require a reasonable accommodation. Almost nobody's going to say that. But if you as the HR lead or the people in charge of workplace accommodations has reason to know that the employee is struggling with an essential function of their job and that they have a medical impairment, it's probably up to you to start the interactive process, that is, a discussion with the employee if they ask for anything about whether there is an accommodation that's reasonable and that would enable them to perform the essential functions of their job. But remember, you don't have to provide an accommodation that creates an undue hardship. And that's a term of art, it's a little bit mushy, but if it creates significant financial or other burdens, you don't have to provide it. So that's all by way of a review. And remember, the accommodation needs to be medically necessary. It's not just the employee's preference. They have to show that it's tied to a medical condition. And certainly you as the employer can ask for documentation for the need to have a reasonable accommodation. And if you have a lot of reasonable accommodation requests, you may have to have a pretty quick response to it. For example, if I have an employee who says, I can't come to work, I'm really anxious about COVID. I'm afraid that I will get it if I come to work. This may be something you've heard. And I have been diagnosed with an anxiety disorder. This is not something that you can make a decision about right away. This probably triggers you to say, I need to do more exploration about what the situation is, what the options are. And so what do you do in the meantime? You may have to create a temporary accommodation and say, okay, for the next week, I'll let you work at home, but it's only temporary while we sort this out, or I might reassign you to another place. So always keep in mind in those kinds of situations that sound like they're going to be a little bit complicated, you can always, as the employer, say, I'm going to do something temporarily while we sort this out, and then you move it along promptly. But you do not have to on the fly say yes or no. You know, you may have to gather medical information. And I do think that's something that we forget about sometimes, that there is that option. So, what do you ask the employee? Well, the first thing you say is, how does your impairment affect your ability to do your job? So the first thing that you can inquire about is how the disability creates a limitation. How does this affect your ability to do your job? And second is how the requested accommodation will effectively address the information. So you can ask, how will this accommodation that you're asking for enable you to perform your job? And then you can engage in the interactive process about whether it will in fact enable the employee to do the job or whether there are alternatives that you should discuss. And remember that a leave of absence can be a reasonable accommodation if there's reason to believe that at the end of the leave of absence they can return to work and do the essential functions of their job. So that's the review of the basic principles. They apply exactly during COVID as they did before. There are a few wrinkles that I want to talk about. So let's talk about COVID in particular. These are the agenda items that I thought would be most helpful. First, talking about how you're accommodating employees' need to have a safe workforce or the steps for minimizing workplace exposures. And that's what you've probably been doing over the last year and a half, but I'm just going to do a review of that. And that is a form of accommodation. You're accommodating employees' need to have a safe workplace. Specific accommodation issues are work from home issues, dealing with mental health issues that may be exacerbated during COVID-19. We probably all have employees who just seem like they've really struggled mentally over the last year and a half. Or if you've been remote, you may not know who has and who hasn't. Addressing long haulers, that is going to be an issue post-pandemic as well. And then related to people who say they can't get vaccinated if you have a mandatory vaccine policy because of a medical condition or because of a sincerely held religious belief. So let's talk about steps for minimizing workplace exposures first. Remember back in March, April, and May of 2020, this was our main focus. How are we going to make the workplace safe for those of you who stayed open because you had essential workers and the rest of us went home and also figured out how to keep people safe? In Connecticut, there were a lot of executive orders passed. Most of those have been rescinded. What's the rule in Connecticut now? Well, now all workplaces can be open, but the Department of Public Health does have the guideline that's existed since I think it's April that says employers should require employees to wear masks if they are unvaccinated or their vaccine status is unknown and they cannot maintain continuous separation from customers or coworkers. So there's three parts of that. One is it's not a mandate. It says they should, and it's from the Department of Public Health. It's not a law. It says employers should, when employees are unvaccinated or you don't know their vaccine status, you should ask them to wear a mask unless they can continuously separate themselves from other people. So the mask issue is still prevalent in some places. I know Stamford and New Haven just rescinded their local mask mandates, and I think other municipalities that have had those will be rescinding them as well. But there's still this guideline out there. So how do you accommodate people and allow employees to be safe? Well, one is to follow the Connecticut Department of Public Health guidance, which I just read to you. You can certainly ask employees if they've been diagnosed with COVID-19 and send them home if they have. The EEOC states that employers can ask employees if they're experiencing symptoms of COVID-19, such as fever, chills, cough, shortness of breath, fever. I know in our firm, we have to fill out, it's an app, a questionnaire of 5 questions, and we have to take our temperatures before we go into work any day. Does anybody else do that at this point? Yeah, it's very easy. It takes literally 10 seconds. And then for contact tracing purposes, if there is an issue, they'll know exactly who was in the office on any particular day. I know those are readily available. What else can you do to keep your workplace safe? You can make sure that you can take temperatures if you want to. You can ask employees to take temperatures. The EEOC has made it clear that employers may take temperatures on site, but you have to handle the medical information as a result of that temperature taking very carefully. So I know employers don't want to do that because of the risks of that information not being kept confidential. The EEOC has said that generally, measuring an employee's body temperature is a medical examination and therefore would not in normal times be permitted, right? All of us know that we can't have medical examinations except in certain circumstances. But here, because the CDC and state and local health authorities have acknowledged community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. However, employers should be aware that some people with COVID-19 don't have temperatures. So you can take temperatures if you want to as one measure. What about people who refuse to undergo those? Well, they don't really have a right to refuse. Most employees do not have a right to refuse and to create danger for their coworkers. Employers can screen applicants as well. So the EEOC has also said that between the time of an offer of employment and between the time of that person's first day of work, you may screen job applicants for COVID-19 by requiring them to report symptoms and test them before they start work. So all of those things are things that you can do as an employer to accommodate the need to create a safe work environment for your employees, and you can require vaccines if you want to do that. So what of this information related to COVID has to be kept confidential? Well, all of it. And that is a burden on employers. All of employees' statements about whether they have symptoms, all employee statements about whether they have COVID, temperature check results if you gather those, symptom screening results if you gather those, and COVID-19 testing results if you gather those, all have to be kept under strict lock and keys, so to speak. Those are extremely confidential, and you have to have protocols in place before you start gathering this kind of information. So by way of summary, what can you do to accommodate safety issues? You can inquire about symptoms, you can take temperatures, you can perform COVID testing, you can screen for symptoms, both employees and applicants, you can require vaccinations, you can require masking, social distancing in the office. You can require some people to work at home on certain days so you have fewer people in the workplace. You can require employees to stay home if they have COVID, if they have COVID symptoms, or if they've been exposed to anyone with COVID symptoms. This is probably much of what we've been doing for a long time, but those are all things that you can do to accommodate people's need to work in a safe work environment. What about accommodation requests under the ADA? So one of these is work from home requests. And I know this is also called remote work, and Timothy talked about some of the tax implications of that. But what about working from home in the first instance? Sometimes we're asked, can you require people to work from home? Yes, if you have a reason to do that. But what about the employee who asks you, you know, I've been working from home successfully for 1.5 years. I just want to keep doing that. Can an employer require an employee to stay home? Yes. But what if the employee, let me go here. What if the employee asks to work from home and you're not requiring it? So for example, can you request medical documentation to confirm the need to stay home? Yes, you can. And even if you're not sending people home, you may require masks in the office, as we said before. And what medical information can you require if someone says, I can't wear a mask in the office because I have a medical condition? Can you then ask for a medical note from a doctor or ask them what medical condition they have that prevents them from wearing a mask in Connecticut? The answer is no, exclamation point. In Connecticut, employers are prohibited from requesting or requiring medical or other documentation to prove that an employee can't wear a mask in the office. In fact, Connecticut specifically says to employees on the website, if you decline to wear a mask or face covering due to a medical condition, you are not required to produce medical documentation verifying the stated condition. So that's different from normal accommodation requests where you can ask for medical documentation, and that's why I wanted to point it out. There is this exception for masking. So what do you do if you have a mandatory mask requirement when people congregate in your conference room and you have 20 people there and you say, in that situation, I want everybody to wear a mask? And your employee says, I can't wear a mask, I have a medical condition. What do you do? Then you figure out if there's another accommodation that will allow that person to attend the meeting or participate in the meeting without a mask. Could be a face shield, it could be sitting in another part of the room, it could be participating in the meeting remotely, or if all else fails, not attending the meeting, but that would be difficult. So you have to think of other things if you have a masking requirement under certain circumstances and the employee says that they can't wear a mask. And just quickly, these cards, yes?
What if you can't make an accommodation? What if you cannot be in a meeting or what have you? It's just you can't do it through Zoom or virtually. What do you do then?
Well, you have to figure out whether the employee should not participate or whether they can be on the phone, or face shields sometimes work. You know, those plastic things with the...
It's okay if they're willing to wear a face shield, just not a mask.
Usually they can. Should I repeat the question? What do you do if they, the question was, what do you do if there's no way to really accommodate the person who can't be at the meeting? Usually you can figure out something, because usually the mask issue is some sort of skin condition or anxiety over having something over their face. The shield is a little bit further away, and usually that can be required. So.
Is there ever a point where, what if they say I don't want to wear a face shield?
Well, then you have to decide if that person just shouldn't attend the meeting.
Because it seems like under the Connecticut law, by saying we cannot ask for any documentation supporting their request or their accommodation, that anybody could say, I just can't wear a mask medically, but we're not allowed to ask for anything. So I feel like anybody could say that. So where's the protection for the employer?
We have had those situations where there have been situations where employers believe that groups get together and they all make that request and it's unfounded. I think you do the best you can. Maybe they don't attend that meeting and they don't get the benefit of the information. If there's no accommodation that would be safe. Now, we haven't talked about the are they vaccinated or not vaccinated issue, which may come into your decision making. I'm assuming that you haven't asked if people are vaccinated. So if you know the person is vaccinated, you might go one way. If they're not vaccinated, you might go another. These are all decisions that you have to make based on your best judgment. What we do know is that these cards are no good. Okay, so if somebody presents you with a mask exempt card that says they're exempt from any ordinance requiring face masks, that is a fake. I know, it could have really good logos. Addressing work from home requests, or as HR people sometimes say to me, oh my gosh, everybody works from home. Wants to work from home now, what do I do? How many of you are kind of coming back into the office, whether hybrid or not hybrid? We are. You know, we're scheduled to come back January 10th. We were going to come back October 3rd and kind of put it off a little bit, and we're planning to come back on a hybrid model. So what do you do as the HR person who gets these requests? I want to start working from home now. And what's the next thing you say as the HR person? Why? Very good. Why do you want to work from home? And these may be some of the answers. I'm very anxious about getting COVID. You know, I'm worried about it. I don't want to come in and take the risk. Long haulers may have physical symptoms that make it difficult for them to come into work. There may be other mental health concerns. The employee may say, I have school-age children at home and I never know when school's going to get canceled, so it's just easier for me to be home. I'm concerned for my at-risk family member. My husband is immunocompromised. If I get COVID, he's in trouble, and so I don't want to take that risk and come into the office. Or, you know, I have family members who need my care at home, whether it's related to COVID or old age or whatever. It's just easier for me to be home to care for this loved one with medical conditions. So which of those have nothing to do with the ADA or medical accommodations? Well, I'll answer that. Care of school-age children, right? The FFCRA is over with, so there's no duty under the Americans with Disabilities Act to accommodate the need to care for school-age children. That doesn't mean you won't do it, and you certainly can go beyond what the law requires, and we encourage flexibility with people's individual circumstances. But the Americans with Disabilities Act does not require you to accommodate the need to be home to take care of kids whose schools are closed. Concern for at-risk family members and care of family members with medical conditions, those aren't covered by the ADA. The ADA requires accommodation for the employee's disability, not for the employee's spouse or family member's disability. That's not to say the FMLA wouldn't kick in, which we'll talk about in a minute. So let's say that an employee comes in and wants to work from home. They're the administrative assistant to the president of your company. And the president says, no way, I need her in the office. It's just too inconvenient for me to call her every time I want her to do something. This work from home thing, I'm glad it's over. I need her in the office. You're the HR person. So what do? You ask the employee, why do you want to work from home, right? And if she says, it's more convenient for me to work from home, that's not an accommodation issue, right? You can grant it, but it's not something that you're required to grant under the ADA. I got used to working from home and I like it and it's easier for me and I'm more productive. I'm really getting a lot more done at home. That's not an ADA accommodation issue. Again, you can grant it if you want to. I got a dog during COVID. It's really inconvenient for me to drive home from lunch every day. I'd really rather work from home at least twice. That's not an accommodation issue. I'm saving on commute time and expense, and I want to just work the extra time. That might be a rational answer, but it's not an accommodation issue. If the person says something like, and I was coming up with this hypothetical, but it's real life, I have an underlying health condition. I'm immunocompromised. I got vaccinated, and then I had an antibody test, and I don't have any antibodies. I got the booster, and I still don't have any antibodies. My doctor says I should not be around unvaccinated people. And you, employer, are not asking about vaccination status. You don't have a mandatory vaccine. My doctor says I cannot be in this work environment. So what do you do under that circumstance? That's the one that you look into more, right? Because that is a compelling medical condition. She has a doctor saying she cannot be in that working environment. You might allow work from home. You might come up with a different accommodation that would address her concerns, working in a private office, away from people, plexiglass, finding another position for her within the company, something like that. And you might have to institute a temporary accommodation, which we talked about, while you sort it out. But that's the kind of situation that you're going to want to look into in terms of medical conditions. So please don't forget the basics about working when you think about working from home. Someone can work from home only if they can perform all the job's essential functions. You need to ask, what is the issue, and are there any other accommodation issues? If in fact that job is better done in the office than at home, is there another accommodation option that would fit the circumstances and address the concerns? Is it reasonable, or does it impose an undue hardship on your business and your president in this particular case? Are there things, does she create binders for physical meetings that she couldn't do if she wasn't in the office? Have the business circumstances changed post-pandemic so that although you could work from home then, now that everybody's in the office, you really can't work from home because you can't do X, Y, Z? And if work from home is not your standard model, can all of the essential functions of the job be conducted remotely? Those are all things to consider when you're considering an employee's request to work from home. So first, you find out the reason for the request. Second, you engage in the interactive process of trying to identify whether the requested accommodation is reasonable and doesn't create an undue hardship, or whether there's something else. What about age? Has anyone had people request to work from home, not because of a medical condition, but because they're older workers? At the beginning of the pandemic, I'll tell you that employers were asking, should I require our older workers to work from home? And to protect them, because this was, remember, we got hit so hard in the Northeast so quickly, and there weren't any good treatments, and a lot of people were dying. And the EEOC did come out with guidance on that, saying that it prohibits employers from simply excluding individuals from the workplace based on age, regardless of intent. And that was pretty clear that that was going to be the answer, but they were very specific that you as the employer can't say, if you're over 65, you have to work from home, okay? All right, let's flip that the other way around. The employee asks to work from home, says, I'm over 65, I would really like to work from home. You can do that if you want to. That's not a request for medical accommodation. But you should talk to the employee about whether what they really mean is a medical condition, because older people tend to have more medical conditions, or whether it really is just because of age. And again, you may want to provide that accommodation, but you don't have to under the ADA if it's simply based on age. Mental health conditions. So there really is no doubt about it. In the last year and a half, both COVID and, I guess, politics have had a profound impact on the mental health of American workers. We've all read the articles about the attacks on airline flight attendants, I know so many people have told me we're all observing people behaving really badly in public, just being more rude and hostile on the street toward one another. There are statistics that support that that is really happening across the country, and we shouldn't take it lightly. And you as HR people and heads of organizations, I'm sure you're up on this, but in October 2020, the Kaiser Foundation said that for the first time, mental health illnesses will overtake obesity in the United States as the most common pre-existing condition for insurance purposes. And the CDC said that the number of adults reporting symptoms of anxiety or depressive disorder increased from 11% in the first half of 2019 to 41.5% in January and February of 2021. So from 11% to 41.5%. In February of 2021, the Kaiser Foundation published a really interesting article I would recommend you take a look at, called The Implications of COVID-19 for Mental Health and Substance Abuse. And there are three things that I took from that. One is that young adults between 18 and 24 are twice as likely as all adults to report new or increased substance abuse or recent suicidal thoughts during the pandemic. Twice as likely in the 18 to 24. So your younger workers are probably more impacted by this. Women are much more likely than men during the pandemic to report symptoms of anxiety and depression. I can see women nodding their heads here. 47% versus 38%. And the last thing is, and I was surprised by this, but I shouldn't have been, essential workers are much more likely than non-essential workers to report depressive disorder, increased or new substance abuse, or suicidal thoughts. And the difference is, on average, between 42% essential workers versus 20 or 10% for non-essential workers. So your younger workers, your women, and your essential workers are under particular strain. So this is a real thing. Oh, and the last one is that 22 to 35% of US employees who have experienced symptoms of depression throughout the COVID-19 pandemic. So this is a real thing, and as a result, we see a dramatic uptick in requests for leaves based on mental disorders or anxiety, depression. So it's important not to dismiss those as general anxiety if in fact the employee is having treatment or is about to have treatment or expresses a mental health issue that really does require accommodation. And remember, if the employee is asking for an accommodation because of higher risk family or other family members, that's not something that's covered by the ADA. But, as I said before, it might be covered by the FMLA. So as we all know, the Family Medical Leave Act, both federal and state, covers the employee's chronic health condition, and it may also cover time off to care for a parent, spouse, or child with a serious health condition. So even though it may not be a request for an accommodation under the ADA, there may be leave that the person is entitled to care for someone who's sick with COVID. Same with school closures, that this is not covered by the ADA. So it's quite a maze. It can make your head spin. You have to think about the ADA, the FMLA, religious accommodations under Title VII, your own policies, your disability, short-term, long-term, and workers' compensation. All of these come into play. In addition to mental health issues, there can be mental and physical disabilities that result from having had COVID. And we've all probably read articles that long haulers very often experience headaches, memory loss, fatigue or brain fog, inability to think straight, and shortness of breath. I think the statistics are that between 27 and 33% of people who had COVID but did not have it seriously enough to be in the hospital. So this is the more minor versions of COVID, 27 to 33% developed some form of long-haul COVID. So it is a very prevalent situation. A lot of people can't work because of that. And so what do you do if somebody comes and says, I need an alternative work schedule, I need to do this or that, or I need time off because I think I have long-haul COVID? You go through the same analysis that you normally would. You figure out if it will impact their ability to work. Does the FMLA apply? Is there a disability at this point which must be accommodated? Do laws require paid leave? Would they apply for the Connecticut paid family medical leave, which you talked about this morning? Are there company policies that would apply? And does the attendance policy come into play? So if COVID creates a serious health condition, make sure that you think about FMLA in addition to reasonable accommodations. And remember, under federal FMLA, they can get 12 weeks, but they have to have worked 1,250 hours or 12 months. But under Connecticut, starting on January 1st, they only have to have worked for you for 3 months. So these can be short-term employees who still get these FMLA benefits. And under the ADA, if you're being asked for an accommodation, remember that if it's a leave of absence, it can be intermittent. How many people here have people on intermittent leave right now, right? It's hard to track, it's a little bit of a pain, but employees who have an accommodation of a leave of absence can take it intermittently, the same under FMLA, and that they can also have a reduced schedule perhaps, or an alternative position. Those are all possibilities, as long as they're reasonable and they don't create an undue burden, and they in fact will enable the employee to do their jobs eventually. So when someone asks for a leave of absence due to a COVID-related issue, you first think about FMLA. That's what I usually tell people. Is there a serious health condition? And if not, or if they've exhausted FMLA, then don't forget about thinking about, is there a reasonable accommodation that I'm entitled to give under the Americans with Disabilities Act? So, reasonable accommodation, no discrimination, confidentiality, and no retaliation under the Americans with Disabilities Act. There is no requirement that the employee make a request for accommodation in writing. And if you're the HR person, you shouldn't ask them to request it necessarily in writing, although you can give them a form that they need to fill out. And remember that other people can ask for accommodations on behalf of employees. The supervisor might ask, you know, this person needs some time off. It doesn't have to be the employee coming out and asking you for the accommodation himself or herself. So what is a reasonable accommodation? I've been throwing that term around. Well, it's defined as a modification or adjustment of any sort to a job or work environment that allows the employee to perform the essential functions of their job, as long as it doesn't create an undue hardship, and as long as it doesn't eliminate essential functions of the job and doesn't create a direct threat of harm. So it can be the kind of normal things we used to think about, like wheelchair ramps, devices, carpal tunnel rests for your wrists, providing specific equipment, modifying the workplace. But what we're seeing more now are really modified work schedules, leaves of absence, job restructuring, temporary light duty, modified policies, and potentially reassignment. Let's talk about mandatory vaccine programs for the end of this and how accommodation plays into those. So I know we asked who had 100 or more employees who will be subject to the OSHA mandate. Are any of you subject to the federal contractor vaccination rules? Okay, some of you. So you're already in the throes of creating mandatory vaccination programs. without the testing alternative. But for many of you who are probably going to think about mandatory vaccine programs now, either as a result of the OSHA regulations if you have 100 or more employees, or because you just decide that that's the right thing for your business to do, you're going to have to address medical accommodations and religious accommodations for employees who say they can't get the vaccine for religious or medical reasons. So how many people either are in the process of or already have mandatory vaccine programs at their companies? We're in the process. Not that many. But a lot of you raised your hands and said you had 100 or more employees, so you're going to have to start thinking about this now, right? What we are seeing is that more of our clients are adopting mandatory vaccine programs. You don't have to unless you fall under the federal contractor requirements or the OSHA guidance that was issued today. But you may. And, or if you're healthcare workers or education, there are some requirements there too. But we're increasingly being asked to help employers with accommodation requests. Just last week, I was telling people at my table that we were asked to help an employer review 4,000 religious accommodation requests that they have received in the last 2 weeks since they announced a mandatory vaccine program. Just to give you an idea of the scope of this, you probably read the article about the University of Connecticut having a mandatory vaccine requirement for students. And when they announced it, the Connecticut Mirror had an article that said as of early August, 771 students had requested exemptions for non-medical reasons, like religious accommodations, and only 55 had requested them for medical reasons. So if you think about it, there aren't that many medical conditions that would preclude you from getting a vaccine. It really would probably have to be something like an allergic reaction and a doctor's note saying you can't get that vaccine because it will be very dangerous. On the other hand, we're seeing a lot of religious exemption requests. And UConn was actually got some backlash for granting 504 of them, according to the article, which annoyed other students who were there, saying a lot of people are not going to be vaccinated. So you can't win no matter what you do. Somebody is going to be mad at you. Yes? No, you can ask for a reasonable accommodation verbally, but you certainly can ask them to fill out a form. I mean, we have specific questions we want to ask if somebody asks for a religious accommodation, for example. And then your medical accommodation, you would follow your normal process. You wouldn't do anything different from that. So what about medical conditions? We just talked about that a little bit. I don't think you will see as many of those because, as I said, there aren't that many medical conditions that would fit this category. But it's clear that a vaccine mandate is permitted. The federal EEO laws do not prevent an employer from requiring all employees physically entering the workplace to be vaccinated for COVID-19. So remember, that can only apply to people who come to your workplace or interact with other employees. If someone is completely remote, that would be different. You may request proof of vaccination, and you have to keep the information confidential. So how does the issue of medical accommodation come up? It comes up with the employee saying, I can't get the COVID-19 vaccine because I have this medical condition that will make it dangerous for me. In that situation, then you have to assess, if in fact they do make that tie to a medical condition, whether there's another reasonable accommodation that would allow them to do their job. And don't forget that you want to make sure that you put employees on notice if you roll out a mandatory vaccine program, that there is a process for requesting accommodations based on religion or medical reasons. You'd want to provide the forms, you'd want to have a process set up at the time that you announce it. The EEOC has said that as a best practice, an employer introducing a COVID-19 vaccination policy and requiring documentation or other confirmation of vaccination should notify all employees that the employer will consider requests for reasonable accommodations based on disability on an individualized basis, the same with religion. So if an employee requests a medical accommodation and the medical condition is substantiated, what kinds of accommodations might be required? It could be testing, it could be wearing a mask, working a staggered shift. There are lots of examples up here. Making changes in the work environment like ventilation systems, permitting working at home, reassigning the employee to other positions, or, as I said before, periodic testing. I'm going to skip a couple here just to keep going. How about accommodating sincerely held religious beliefs? And that's the one that's going to be the most difficult. What's required for an employee to get a religious exemption? There has to be a sincerely held belief. It has to be religious in nature, not personal and not political. And it has to prevent, the religious belief has to prevent the employee from getting the COVID-19 vaccine. So what are we seeing here? I'm going to skip a couple. Sincerely held. It's hard to judge whether someone is sincere about their beliefs, right? And pre-COVID, whenever anyone asked not to work on Saturdays because of a religious observance, or they needed to pray in the middle of the day, those requests for religious accommodations were routinely granted. I'm sure you've had those from time to time. It's a little bit different now with COVID. The kinds of things that we're seeing are, certainly some people have sincerely held religious beliefs, but we're seeing a lot of things like, my body is my temple, right? And that's it. That's all they write on the request. Or I don't want to corrupt my body by putting foreign objects in it. I trust in God to keep me safe, and He's kept me safe up to this point. You know, that kind of general language. And you can buy a religious exemption online. How many have seen the ones from Pastor Dave? Have you gotten them? I've seen 50 of them. True Hope Ministries used to charge $29, now it's $129. And you get a letter, and it says, this person is a member of my church, and they have a sincerely held religious belief. And depending on where you live, it might come from a P.O. box in Alabama or Southern California. So apparently that's where the church is, in a P.O. box. There are sincerely held religious beliefs that might preclude this, but there's also a lot of nonsense out there. So prepare yourselves. And how you treat this, you can grant everything, or you can really scrutinize these a little bit more. No established religion has publicly come out against the COVID-19 vaccine. It's difficult to judge sincerely held, but there are questions that you can ask about whether the person has gotten other vaccines, whether the person has taken acetaminophen or ibuprofen, which apparently the testing for that used fetal cells just like any of the other vaccines. The flu vaccine used the same process. It also has to be a religious belief. So if an employee says that it's because of their political beliefs, or they're afraid of the side effects, those are not religious beliefs. So it has to be sincerely held, it has to be a religious belief. And in fairness, just because it's not an established religion doesn't preclude it from being legitimate. You know, there are many religions that you as the employer may not know about that actually are practicing. And so you can't preclude it outright, but there are many questions that you can ask in follow-up to figure out if this is a practice they've engaged in throughout their whole lives, or whether this is really just a way to avoid getting the vaccine. So we have covered a lot. We covered ADA accommodations in general, how to minimize workplace exposures as an accommodation, work-at-home requests, long haulers, mental health issues, and accommodations for medical conditions and sincerely held religious beliefs. Do you have any questions in the next 3.5 minutes?